Lesson 1A, Addition, Act 208, Online Training. Fair Labor Standards Act, Lesson 1A, Addition, also known as FLSA. Act 208, Session Laws of Hawaii, gives the Board of Private Detectives and Guards authority to add subjects to the training curricula. This is one of the additional subjects. What the Hawaii law states. Section 463-10.5, subsection D, also known as Act 208, Hawaii Revised Statutes, states classroom training shall include, but not be limited to, subsection 1, state and federal law regarding the legal limitations of the actions of guards. This lesson is on the Fair Labor and Standards Act of the federal law. The highlights of the FLSA. The FLSA sets minimum wage, overtime pay, record keeping, and youth employment standards for employment subject to its provisions. Unless exempt, covered employees must be paid at least the minimum wage and not less than 1 1/2 times their regular rates of pay for overtime hours worked. Posting. Employers must display an official poster outlining the provisions of the Act, available at no cost from local offices of the Wage and Hour Division. Employer required to keep records. Records are required. Every covered employer must keep certain records for each non-exempt worker. The Act requires no particular form for the records, but it does require that the records include certain identifying information about the employee and data about the hours worked and the wages earned. The following is a listing of the basic records that an employee must maintain. Employee's full name and social security number, address including the zip code, birth date if younger than 19, sex and occupation, time and day of week when employee's work week begins, hours worked each day, total hours worked each work week, basis on which employees' wages are paid, for example, $15 per hour, regular hourly pay rate, total daily or weekly straight time earnings, total overtime earnings for the work week, all additions to or deductions from the employee's wages, total wages paid each pay period, and date of payment and the pay period covered by the payment. How long should these records be retained? Each employer shall preserve for at least 3 years payroll records, collective bargaining agreements, sales and purchase records. Records on which wage computations are based should be retained for 2 years, that is, time cards and piecework tickets, wage rate tables, work and time schedules, and records of additions to or deductions from wages. These records must be open for inspection by the division's representatives, who may ask the employer to make extensions, computations, or transcriptions. The records may be kept at the place of employment or in a central records office. What is piecework? It is common for companies to pay their non-exempt, that is hourly workers, on a piece rate, that is measurable work completed, instead of by the hour. The purpose of this method of compensation, which is perfectly legal if properly executed and documented, is to motivate employees to heighten their productivity beyond what a mere hourly wage would yield. Where many construction companies and other payers of piece-based compensation get in trouble is that they neglect to record and observe actual hours worked, which can put them in non-compliance with the Fair Labor Standards Act. When is overtime compensation required? Overtime is paid when an employee works more than 40 hours in a work week. Hours worked in excess of 8 hours a day is not considered overtime, except when work is performed on a state or county public works construction project. What is the labor law that governs meal breaks? In Hawaii, the only requirement for breaks is found in Chapter 390, Hawaii Revised Statutes, Child Labor Law, which requires employees to provide at least a 30-minute rest or meal period after 5 consecutive hours of work for 14 and 15-year-old minors. An employee's policy would determine whether or not breaks are provided for other employees. What are the rest periods between 8-hour work shifts? There is no state law that requires a minimum number of hours in which an employer must provide an employee between their daily 8-hour work shifts. You may contact the nearest office of the U.S. Department of Labor, Wage and Hour Division for information on federal laws. What is the FLSA requirement on breaks and meal periods? The FLSA does not require breaks or meal periods be given to workers. Some states may have requirements for breaks or meal periods. If you work in a state which does not require breaks or meal periods, these benefits are a matter of agreement between the employer and the employee or the employee's collective bargaining representative. What generally occurs is an unpaid meal break of 30 to 45 minutes. It is an agreement between the employer and employee. Can an employer pay compensatory time instead of overtime? Under Chapter 387, Hawaii Revised Standards, Wage and Hour Law, there is no provision for compensatory time off. However, the department recognizes the use of compensatory time or comp time in lieu of overtime pay as follows. Number one, the compensatory time is applicable only to employees who are on a salary basis. Number two, the employee must be allowed to take the compensatory time off within the same pay period in which the overtime is worked. And number three, the compensatory time is earned at 1 1/2 times the number of overtime hours worked. What about health care? If you work at least 20 hours a week, there are obligations for your employer to provide certain benefits under the Hawaii prepaid health care law. You deserve a fair wage and to be paid accordingly. If you think your compensation is in error or there is a mistake, ask your supervisor for permission to speak with the payroll department. There is no exam for this lesson addition. This concludes lesson 1A, addition, federal law concerning security guards, FLSA. Thank you very much.